SchnitzelNinja.
Laura Owens v. Michael Marraccini, case number FDV-18-813693. Motion to dismiss DVRO pursuant to CCP Section 473B-D, Notice of Intent to Seek Sanctions pursuant to Section 271. Introduction. Respondent Michael Marraccini moves to vacate the Domestic Violence Restraining Order obtained by petitioner Laura Owens in January 2018 on the grounds that the order was procured through fraud. What has become abundantly clear from all the filings addressing Owens' requested renewal of the underlying DVRO is one fundamental truth. Laura Owens will not be able to refute evidence based on Owens' admissions, independent witness statements, findings from separate court proceedings, a recent felony indictment for fraudulent schemes, perjury, and submitting false evidence, which proves Owens' fabrication of allegations of abuse and the presentation of false evidence to obtain the 2018 restraining order. In doing so, Owens deprived Marraccini of a fair opportunity to defend against the DVRO, satisfying the definition of extrinsic fraud that warrants equitable relief. Marraccini, compelled by the concealment of material facts of Laura Owens' scheme, stipulated to the DVRO. He now stands resolute in asking this court to vacate the fraudulently obtained order in the interest of justice, ending a 7-year-old prejudicial restraint on his freedoms, on his liberties, that Owens has used to taunt him wherever he goes. Owens, seeped in animosity, the unearned robes afforded to genuine victims of abuse and criminal intent, has sought Marraccini out to affect his life in any possible way. Marraccini has moved on. He started a family with a beautiful wife and children. He has lived a crime-free life, full of love and affection from those he actively supports. He's moved on in every imaginable capacity. But for Owens' criminally inspired request to grasp at the ghosts of a relationship she relentlessly coveted, that Marraccini wants to erase from his existence. CCP Section 473 affords him that opportunity. Factual and procedural background. Owens and Marraccini were in an on and off relationship from 2016 until mid-2017. On January 7th, 2018, an incident occurred in which Owens confronted Marraccini and his sister in public, screaming accusations at Marraccini, prompting him to ultimately call the police to defuse the situation. 2 days later, on January 9th, 2018, Owens filed a request for a domestic violence restraining order in this court, which the court granted on a temporary basis on January 10th, 2018. Owens' application for the DVRO alleged that Marraccini subjected her to extreme physical and emotional violence over the course of their relationship. Owens submitted photographs of injuries that she claimed were caused by Marraccini's abuse, when in fact those photos were from an unrelated accident, Owens falling off a horse. Footnote 1. In 2018, Owens submitted 4 photographs to this court in support of her declaration. February 27 photographs, 2 photographs purporting to show a bruise on Owens' arm are dated February 18, 2017. During that same month, Owens competed in 3 horse shows, including one held from February 15th to 19th, 2017. March 2017 photograph. A 3rd photograph depicting redness around Owens' eye is loosely dated March 2017. That month, she competed in 2 horse shows, the Winter Equestrian Festival, March 15th through 19th, 2017, WAF 10, and the Blenheim Spring Classic 2, March 29 through April 2nd, 2017. May 2017 photograph. A 4th photograph showing redness around Owens' eyes and cheeks is loosely dated May 2017. In that month, she competed in 3 horse shows, the Del Mar National Horse Show, the Sonoma Horse Park Spring Classic, and the Central California Classic. Despite Owens' extensive allegations of abuse, these 4 photographs constituted the entirety of her photographic evidence. Owens also claimed the abuse was so severe it drove her to seek inpatient psychiatric treatment, a claim which she herself had contradicted in prior filings. Marraccini categorically denied Owens' allegations. On January 22, 2018, Marraccini filed his DV-120 response refuting every claim and alerting the court to Owens' history of manipulative conduct, including instances where Owens had fabricated pregnancies and made conflicting medical claims during their relationship. Both parties submitted additional declarations and some third-party witness statements in preparation for an evidentiary hearing on the DVRO. The evidentiary hearing, originally set for January 26, 2018, was continued to allow discovery, including depositions of the parties and further evidence gathering. By July 2018, Marraccini was emotionally and financially exhausted due to the petitioner's barrage of false narratives. Rather than continue to engage with what he knew were baseless accusations, Marraccini made the practical decision to resolve the matter by stipulation. On or about July 10, 2018, Marraccini, quote, simply wishing to move on, end quote, agreed to enter into a stipulated restraining order resulting in the issuance of a 2-year DVRO through July 10, 2020, with no admissions of wrongdoing and no factual findings against him. The 2018 DVRO was issued without any finding that Marraccini committed domestic violence. The July 2018 stipulated DVRO was set to expire on July 10, 2020. On that date, petitioner Owens sought a renewal of the restraining order for an additional 5 years. The court granted petitioner's renewal requested on September 11, 2020, extending the DVRO to July 10, 2025. Petitioner has since treated the existence of the DVRO as a tool to bolster her self-portrayal as a domestic violence survivor. Between 2021 and 2024, petitioner made multiple public statements referencing the restraining order and accusing Marraccini of heinous abuse, including a TEDx talk in January 2022 and even a published essay, which was later removed due to questions about its credibility. In 2021 to 2023, petitioner became involved in litigation in Arizona, where she accused at least 2 other men of abuse after falsely claiming to be pregnant with their children, strikingly similar to her modus operandi with Marraccini. In one case, Owens obtained a protective order against a man, Greg Gillespie, after he ended their relationship. In another, she obtained a restraining order and filed a paternity suit against a former Bachelor TV show star, Clayton Echard, following an alleged twin pregnancy. These out-of-state matters culminated in June 2024 when the Maricopa County Superior Court in Arizona conducted a trial on petitioner's paternity claims against Mr. Echard. In that proceeding, evidence was presented that petitioner had never been pregnant at all, that she had fabricated evidence, including bogus positive pregnancy tests and doctored medical records, and that she had lied under oath in support of her claims. The Arizona court expressly found that petitioner Owens had provided false testimony and that her petition was, quote, fraudulent, end quote, as part of, quote, a pattern of similar, if not identical, behavior, end quote, in comparison to her prior schemes. The court noted that Owens' claims were not credible and had been concocted to manipulate the targets of her accusations. Petitioner was ordered to pay over $149,000 in attorney's fees to Mr. Echard as a result of her bad faith, fraudulent conduct. Shortly thereafter, in May 2025, petitioner was indicted by a grand jury in Arizona on 7 felony counts, including fraudulent schemes, perjury, forgery, and evidence tampering, all arising from her elaborate false pregnancy and abuse scams in the Echard matter. It is against this backdrop that petitioner filed yet another request to renew her DVRO against Marraccini on or about July 10, 2025, seeking to extend the restraining order permanently as the July 2025 expiration approached. Owens' renewal request is set for a hearing in October 2025. Marraccini has opposed the renewal and now additionally brings an immediate motion to vacate the original DVRO on the grounds of extrinsic fraud, citing newly discovered evidence that was unavailable at the time of the 2018 stipulation. New evidence of extrinsic fraud, including unknown evidence from the 2018 stipulation, allows this court to vacate the 2018 orders that have been obtained through mistake or excusable neglect based on what is now known to be Laura Owens' fraudulent scheme, perfected over the course of nearly a decade. The evidence now available paints a devastating picture of petitioner's lack of truthfulness and her abuse of the judicial process. Marraccini urges the court to consider the full evidentiary record, which was not available at the time of the 2018 DVRO, and to exercise its authority to vacate an order that was fundamentally built on fraud. 1. Points and authorities. Relief under CCP Section 473D and equitable power. Courts have the authority to set aside void judgments or orders upon motion by either party after notice to the other party. Notice has been achieved under the instant case by virtue of Marraccini's filed response to Owens' DVRO renewal request filed August 25, 2025, and through this filed motion. CCP Section 473 codifies the court's inherent power to vacate void judgments. In People v. 1941 Chrysler 6 Touring Sedan, the court declared that a void judgment could be set aside under California Code Civil Procedure Section 473. In National Diversified Services, Inc. v. Bernstein, the court clarified that California Code Civil Procedure 473 reflects the court's inherent power to address void judgments. In addition to statutory authority, courts possess inherent equitable powers to set aside judgments obtained through extrinsic fraud or mistake, even when statutory deadlines have expired. Extrinsic fraud occurs when a party is prevented from fully participating in the case due to deception or misconduct by the opposing party, such as being kept in ignorance of the proceedings or being misled into not defending the case. In Rodriguez v. Cho, the court reaffirmed that relief could be granted under equitable principles if extrinsic fraud or mistake prevented a party from presenting their case. The court in Oliveira v. Grace also highlighted that equitable relief could be sought through a motion in the original action or an independent action in equity, provided the fraud or mistake was extrinsic. The distinction between extrinsic and intrinsic fraud is critical. Intrinsic fraud, such as perjury or forged evidence, and there is certainly plenty of that in this case, presented during the trial does not warrant equitable relief because the affected party had the opportunity to address it during the proceedings. In contrast, extrinsic fraud involves circumstances that prevent a fair trial, such as a lack of notice or deliberate concealment of material facts. Extrinsic fraud must relate to the manner in which the judgment was procured, not the issues decided in the judgment. Hanley v. Hanley. In addition, the courts have recognized that the terms extrinsic fraud and extrinsic mistake are broadly interpreted to encompass circumstances that deprive a party of a fair hearing, even if the circumstances do not strictly qualify as fraud or mistake. This principle was discussed in Remarriage of Park and reaffirmed in subsequent cases. California courts have consistently articulated a three-part test for granting equitable relief from a judgment on the grounds of extrinsic fraud or mistake. The moving party must demonstrate 1. A meritorious defense to the claims upon which the judgment was entered. 2. A satisfactory excuse for not fully presenting that defense in the original action. And 3. Diligence in seeking relief once the fraud or mistake was discovered. The courts have also clarified that while there is no strict deadline for filing a motion based on extrinsic fraud or mistake, the motion must be made within a reasonable time after the fraud or mistake is discovered. This requirement is closely tied to the principle of avoiding prejudice to the opposing party, as highlighted in Raplea and other cases. A domestic violence restraining order, though civil in nature, is a serious order often made under expedited circumstances. The statutory framework and case law emphasize the significant impact and purpose of DVROs in protecting individuals from abuse, as seen in the broad legislative intent to prevent domestic violence and the serious consequences of violating such orders. A DVRO obtained through extrinsic fraud may be vacated in equity. If a court finds that a restraining order was procured through deception or false evidence, the proper remedy is to set it aside, thereby preserving the integrity of the court's process. The policy favoring finality of judgments yields to fraud that undermines the fairness of the original proceeding. The court has the authority and duty to vacate a DVRO if evidence shows it was obtained by extrinsic fraud. Argument. 1. Marraccini is not time-barred under Section 473. California Code Civil Procedure Section 473 provides that a motion for relief from a judgment, order, or proceeding must be made within 6 months of the entry of the judgment or order. This 6-month limitation is jurisdictional and cannot be extended under ordinary circumstances. However, California courts recognize an exception to this limitation in cases involving extrinsic fraud or extrinsic mistake. Extrinsic fraud occurs when a party is prevented from fully participating in the proceedings due to the opposing party's deceit or concealment of material facts. Marraccini challenges the 2018 Domestic Violence Restraining Order under California Code of Civil Procedure, Section 473, and contests its subsequent renewals based on the lack of litigation, absence of findings of domestic violence, and the petitioner Owens' documented history of fraudulent conduct. Under California Code Civil Procedure Section 473, a party may seek relief from an order or judgment if it was obtained through mistake, inadvertence, surprise, or excusable neglect. The stipulated DVRO was issued in 2018, was not litigated on its merits, and was agreed to under duress and exhaustion, as he was emotionally and financially drained by Owens' false allegations. The stipulated order contained no findings of domestic violence, which weakens its evidentiary basis for renewal. Although statutory relief under Section 473 would normally be time-barred, the doctrine of extrinsic fraud applies. Marraccini did not know and could not reasonably have known that Owens' conduct rose to the level of extrinsic fraud until recently. Owens' actions deprived him of a fair opportunity to present his defense through material concealment of facts, which satisfies the criteria for equitable relief beyond the 6-month jurisdictional bar. In such cases, no statute of limitation applies, providing the aggrieved party seeks relief within a reasonable time. On May 25, 2025, Laura Owens was indicted on 7 felony counts, including fraudulent schemes, 4 counts of perjury, forgery, and evidence tampering. Marraccini is a named witness in the state of Arizona's case against Owens. This indictment represents the first official corroboration that Owens' conduct was criminal in nature, and it provided Marraccini with confirmation of the extrinsic fraud that had previously deprived him of a fair trial. Owens sought renewal of the DVRO in July 2025, and Marraccini filed his motion in September 2025. Accordingly, the motion was brought within a reasonable time, satisfying the requirements of Section 473. 2. Owens' pattern of deceit constitutes extrinsic fraud. Laura Owens has developed a scheme she frequently imposes on men she dates. 1. Initial manipulation. Owens begins relationships quickly, fostering dependency with rapid discussions of family and commitment. Within months, she falsely claims pregnancy, manipulating photographs and documents to lend credence to her narrative. The takeaway: Owens expertly creates emotional traps, setting the stage for deeper deceit. 2. Crisis fabrication. Miscarriage, abortion, inpatient mental health care, cancer, suicidal ideations. Following the initial deceit, Owens invents medical emergencies, such as miscarriages, offering fake evidence like manipulated test results. She assumes false identities to bolster these claims, fabricating correspondence from supposed allies or medical professionals to strengthen her lies. This step illustrates her meticulous crafting of fabricated crises to deepen her emotional control. Footnote 2. With Mike Marraccini, she claimed multiple miscarriages and abortions in 2016 to 17, while claiming to be pregnant with twins. With Clayton Echard, she produced falsified ultrasound images and claimed to be pregnant with twins. 3. False allegations. Owens then escalates by falsely accusing her partners of abuse, presenting unsubstantiated claims of assault and harassment. This includes submitting forged records and photographs as false evidence. Publicly posing as a victim allows her to promote her false narrative. In each instance, evidence contradicts her claims, as courts have often dismissed her lawsuits and noted her lack of credibility. The pattern demonstrates her consistent use of deceit as a means to manipulate those who dare reject her. 4. Assuming the identity of fake people. Owens assumes the identities of aliases or real individuals to support her conjured crises. For example, Dr. John C.K. Chan is an actual medical professional for whom Owens authored forged medical letters purporting to be from Dr. Chan, a gynecologic oncologist, stating she had ovarian cancer and urging her partner to be supportive. She forged notes from Dr. Rebecca Yee. Owens faked communications from entertainment manager David Katz in an attempt to mislead Marraccini into thinking Mr. Katz would represent him in his podcast venture with Owens. Owens claimed to have friends and associates who supported her story of being pregnant with twins. The court later found these claims unsubstantiated. 5. Forged medical records and injury photos. To bolster her lies, Owens fabricates documents and recycles unrelated injuries as abuse evidence. Footnotes 3 and 4. 3. Owens attached a forged letter purporting to be from Dr. John C.K. Chan, trying to convince Marraccini that she had cancer. 4. With Marraccini, she submitted photos of bruises from her horseback riding accidents, claiming they were caused by abuse. She also sent him a photograph of what appeared to be a positive pregnancy test. With others, she submitted videos of ultrasounds purporting them to be genuine evidence of pregnancy, when in fact the ultrasounds belonged to her sister. Over a 10-year span, Owens manufactured medical proofs to prop false narratives, forging an oncology letter, Dr. John C.K. Chan, claiming an oophorectomy and surgical abortion via purported notes, Rebecca Yee, M.D., footnote 5. Laura Owens falsely used Rebecca Yee's name, a real physician, in 2016 to lend credibility to her fabricated medical crises, including alleged pregnancy complications. There is no evidence that Dr. Yee corroborated Owens' claims. Texting HCG and oncology materials, and rebranding horsefall injuries as domestic violence bruises. In Arizona, investigators found she altered an ultrasound image and fabricated a pregnancy video, and filings show she submitted falsified medical records to her own expert. A judge concluded she knowingly presented false claims and referred her for prosecution, now charged with fraud, forgery, perjury, and evidence tampering. Together, these items form a continuous pattern of medical evidence fakery used to mislead partners and courts. 6. Restraining orders. Over the past decade, Laura Owens has repeatedly presented herself as a victim of abuse, alleging physical assault, sexual assault, stalking, harassment, and pregnancy-related coercion by numerous men. In each known instance, however, her claims have been unsubstantiated, contradicted by evidence, or proven to be false outright. Courts have dismissed her lawsuits and, in the most egregious case, found that Owens fabricated evidence and lied under oath. Owens often makes such accusations reactively, for example, after a breakup or after the other party seeks help or legal action against her, and she frequently invokes false pregnancies or health crises as part of the narrative. In several cases, Michael Marraccini, 2018, Greg Gillespie, 2021, and Clayton Eckert, 2023, obtained or attempted protective orders against the men only after they sought to distance themselves or took legal action against her. 7. Public victim narrative. Owens then uses the existence of a DVRO or court filing to promote herself as a survivor in public forums, TEDx talks, essays, and podcasts, attempting to garner sympathy and credibility while vilifying her former partner. 8. Collapse of the fraud. Over time, her fabrications unraveled under scrutiny. Independent courts and law enforcement eventually found her claims to be baseless, leading to dismissals, findings of fraud, and most recently, a felony indictment for perjury, forgery, and fraudulent schemes. It was impossible for Marraccini to have understood at the time that he was dealing with a serial fraud. Corroboration that Laura Owens is a criminal. Owens pursued a paternity claim in Arizona against a public figure, a former reality TV bachelor, claiming she was pregnant with his twins, only to have those claims exposed as elaborate fabrications. The Arizona judge, after a full evidentiary hearing, found Owens' testimony to be wholly not credible, describing her claims as unreasonable and without basis or merit. The court noted that Owens had presented false claims and falsified evidence and accused her of wasting the court's time with her lies. In fact, the Arizona judge was so alarmed by Owens' conduct that she referred the matter to prosecutors, observing that Owens appeared to have a pattern of similar fraudulent behavior in court. A grand jury thereafter indicted Owens on 7 felony counts. The indictment charges Owens with fraudulent schemes, forgery, 4 counts of perjury, and tampering with physical evidence. Investigators found that Owens went to extreme lengths to manipulate the legal process. She allegedly altered ultrasound images, fabricated a pregnancy video, and lied repeatedly under oath in the Arizona case. These are not mere allegations by Marraccini. They are findings and charges by courts and law enforcement authorities demonstrating Owens' propensity to lie to courts and manufacture evidence to achieve her ends. Corroboration of Owens' fraudulent conduct constitutes extrinsic fraud. Marraccini's discovery of Owens' fraudulent conduct in subsequent legal proceedings constitutes extrinsic fraud. California courts have consistently held that extrinsic fraud justifies equitable relief from a judgment or order, even after the expiration of the 6-month period, under California Code Civil Procedure Section 473. Here, Owens' pattern of deceit, as documented in the Arizona court findings and her subsequent indictment, demonstrates that she engaged in a scheme to manipulate the legal system and fabricate allegations against Marraccini. This conduct prevented Marraccini from fully litigating the 2018 DVRO, as he had no way of knowing Owens' misconduct amounted to a fraudulent scheme to harass and stalk him for the duration of the order, or that she would continue this conduct indefinitely. This was bigger than the mischaracterization of photographs, he said, she said, and a little minor perjury. This was the concealment of a full-on fraudulent artifice, ripe with false medical evidence, false communications, a concerted emotional harassment manipulation campaign, and a concerted effort to ruin Marraccini's life. Under California's 3-part test, Marraccini must show 1. A meritorious defense, 2. A satisfactory excuse for not presenting a defense in the first place, and 3. Diligence in seeking to set aside the judgment once discovered. 1. Meritorious defense. To satisfy this element, the movement must demonstrate facts indicating that a different result would have been reached if the case had been defended. For example, in People versus One Parcel of Land, the defendant showed a meritorious defense by declaring she did not knowingly allow drug trafficking on her property. Similarly, in County of LA versus Warmoth, DNA evidence was cited as potentially satisfying to the meritorious defense requirement, if accurate. Marraccini's defense is that Owens' abuse allegations were false, fabricated from whole cloth. Substantial new evidence now confirms that Owens is a serial liar who weaponizes false allegations, positioning herself as a victim to torment men who have no interest in dating her. Had Marraccini been able to present new evidence of Owens' fraudulent scheme, such as the criminal indictment and findings by other courts that anything Owens claims cannot be trusted, including Judge Motta's findings, it is highly probable that no reasonable court could have issued the DVRO. The evidence suggests that the likelihood of a different outcome was significantly high. If the court had the opportunity to learn the full meritorious scope of Owens' claims, there would have been a different result, satisfying the meritorious defense requirement. 2. Valid excuse for not presenting the defense. The movement must provide a satisfactory explanation for failing to present a defense in the original action. In People v. One Parcel of Land, the defendant's attorney's misconduct, including failing to oppose the default judgment and not returning calls, was deemed a valid excuse. California courts have emphasized that the excuse must rise to the level of excusable neglect or positive misconduct, as opposed to mere inexcusable neglect. Extrinsic fraud typically exists where, quote, a party is deprived of his opportunity to present his claim or defense to the court, kept in ignorance of the true facts, or in some other manner fraudulently prevented from fully participating in the proceeding, end quote. That is exactly what occurred here. Owens' fraudulent conduct, quote, prevented a fair adversary hearing, end quote, by inducing the court to decide the case on false information. Through perjured testimony and fabricated corroborating evidence, Owens misled the court and thwarted Marraccini's ability to challenge her claims at the evidentiary hearing. Marraccini had no way to expose Owens' lies at the time. The falsity of her testimony only came to light years later. Thus, unlike a mere case of intrinsic fraud, for example, perjury that could have been exposed at trial, Owens' actions amounted to extrinsic fraud because they, quote, fraudulently prevented Marraccini from fully participating in the proceeding, end quote. In essence, Owens' scheme robbed Marraccini of any meaningful chance to present his defense, which is precisely the kind of injustice California courts will not tolerate. 3. Diligence in seeking relief. The movement must act promptly upon discovering the fraud or mistake. In People v. One Parcel of Land, the defendant demonstrated diligence by securing new counsel and filing for relief within a month of discovering the default. Courts have stressed that a lack of diligence can bar equitable relief, as seen in Friedman v. Pack Gas and Electric Company, where a delay of nearly 3 years was deemed insufficiently diligent. Marraccini satisfies this standard. The record shows that Owens' fraud remained well concealed until recently. It was only through later developments, including documentation of her perjury and falsified evidence, that Marraccini discovered the depth of Owens' deception. Marraccini did not sleep on his rights after this discovery. To the contrary, he acted with appropriate diligence. May 25, 2025, Owens was indicted on 7 felony counts, including fraudulent schemes, perjury, forgery, and evidence tampering. July 10, 2025, Owens filed a request to renew the DVRO, extending its effect until July 10, 2025. September 11, 2025, Marraccini responded by filing this motion to vacate following a thorough investigation into Owens' deceitful conduct. Through these actions, Marraccini has demonstrated reasonable diligence in seeking relief after discovering Owens' fraud. There has been no prejudice to Owens in the timing, as she sought renewal of the 2018 DVRO prior to this filing in July 2025. This was after her criminal indictment in May of 2025. Marraccini brings this motion a little over a month after Owens' request to renew, and after he has substantially replied to Owens' allegations, and after a new investigation into the layers of deceit that he suffered now for nearly a decade. 3. Owens' fraudulent conduct undermines the legitimacy of the DVRO. Relief is right here. To leave the 2018 DVRO is to bless a fraud on the court. The order was intended to protect genuine victims, not to arm a liar. Owens used it to sell her false story of being a survivor. That lie stains the law and weakens faith in it. The courts have stated that they will not allow their orders to be used as tools of deceit. When fraud wins an order, the court has the power to strip it away. There is now strong evidence that Owens won the DVRO on a lie. The order was made without any finding of abuse. Her deceit is plain. To maintain the order would be to perpetuate the fraud. It would allow her to use the court's seal to pose as a victim, to tarnish Marraccini's name, and to twist the truth. The courts of California have the power to stop this. In Oliveira v. Grace, the court stated that equity may strike a judgment when the need for justice outweighs the pull of finality. This is such a case. In the marriage of Park, the court said fraud that keeps a man from a fair hearing is enough to open a closed door. Finality does not save a lie. Owens used the DVRO to dress her falsehoods in law. That abuse tips the scales. The court must guard the truth of its orders. That weighs far more than Owens' thin claim to an order won by fraud. Relief here serves the purpose of law. The DVPA was made to protect the truth. It was made so the courts could believe those in need. When Owens lied, she broke that trust. She hurt Marraccini, and she hurt real victims who come in fear and in honesty. To strike the order is to say the law is for protection, not for revenge or vanity. To leave it is to reward her lies and punish a man who did no wrong. That cannot stand. 4. Relief is necessary to prevent further misuse of the DVRO. The 2018 order must be struck. If it stands, Owens will continue to use it to harm Marraccini and possibly others. To leave it is to reward her lies. It would give her leave to twist the courts again. The Arizona court saw it, her pattern of false claims. Marraccini was likely one of the first. The law cannot be bent to serve such deceit. For Marraccini, the order still cuts deep. A DVRO carries weight. It brands a man. It follows him professionally, in his right to hold a gun, in his name. Each time he has to fly, TSA pulls him aside. They take him to a small room. They question him, sometimes for hours. They treat him as if he were a criminal. Yet no court has ever found he did wrong. Justice calls for Marraccini's name to be cleared. The order was born of fraud. Lifting it now harms no one. Their relationship ended long ago. Marraccini lives in California. Owens went to Arizona. She chased other lawsuits. She ran her fraudulent scheme on others. Whatever need she claimed in 2018 was never real. There was no cause then. There is none now. Marraccini has moved on. He has a wife, 2 children, and a life of his own. It is a life Owens wanted, but could never have. She should not matter to him now. She should be nothing. A sour memory fading in the sun of what he has built. The court holds the chance to end this, to strike down the wrong, to guard others from the reach of Owens and her predatory ways. 5. Sanctions are warranted under Family Code Section 271. Respondent seeks a sanction award of the entirety of Mike's legal fees pursuant to Family Code Section 271 for the attorney's fees and costs incurred due to petitioner's conduct in this litigation. This filing serves as a notice that respondent will pursue sanctions based on petitioner's misuse of the DVRO process, her fraudulent claims, and the unnecessary legal expenses her conduct has caused. By including this notice in the present motion, respondent satisfies the statute's procedural requirement and ensures petitioner has a fair opportunity to address the sanctions request. Respondent submits that the court may rule on sanctions with a motion to vacate or, alternatively, defer the determination to a later hearing after the DVRO is resolved, with this filing preserved as timely notice of respondent's intent to seek relief. Respondent further seeks sanctions under Family Code Section 271 in light of petitioner's conduct, which can be accurately described as a litigation ambush. Petitioner's actions in obtaining and litigating the Domestic Violence Restraining Order have flagrantly violated the Family Code's policy favoring cooperation and settlement. This litigation ambush is characterized by petitioner's fraudulent and misleading behavior, making a deliberate attack on judicial resources and fairness. 1. Fraudulently procured the DVRO. Petitioner obtained the restraining order through false and/or misleading representations, effectively perpetrating a fraud on the court during this ambush. 2. Misled the court and abused the DVRO process. The petitioner presented misleading evidence and omitted testimony to maintain the DVRO, further exemplifying the ambush strategy that undermines the integrity of the proceedings. This misuse echoes the core purpose of Family Code Section 271, which penalizes tactics that price parties out of justice and discourage cooperation, emphasizing the need for fair proceedings. 3. Forced unnecessary fees on litigation. By pursuing an unwarranted DVRO, petitioner has turned this ambush into a costly affair, compelling respondent to incur substantial attorney's fees and costs to defend against the order and now seek its dismissal. This misconduct has escalated the conflict, prevented early settlement, and imposed unnecessary litigation expenses on respondent. Such conduct is exactly what Family Code Section 271 is meant to deter. Section 271 allows the court to award attorneys' fees and costs as a sanction based on conduct that furthers or frustrates the law's policy to promote settlement and reduce litigation costs by encouraging cooperation. The statute's purpose is not simply fee shifting, but to push bad behavior and encourage cooperation in family cases. Here, petitioners' bad faith tactics, executed under the guise of a litigation ambush, have clearly frustrated the process of the law by undermining settlement and increasing costs, triggering Section 271's applicability. Sanctions must be scaled to the payer's ability to pay and must consider the financial circumstances of both parties. Sanctions under California Family Code Section 271 must not impose an unreasonable financial burden. The court has a duty and the authority to impose sanctions for conduct that frustrates settlement or increases litigation costs, aligning with the policy goals of California Family Code Section 271. However, it is important to note that Section 271 does not require the conduct to arise to the level of bad faith or frivolousness, as is required under the other statutes, like California Code Civil Procedure Section 128.5. Instead, it focuses on whether the conduct frustrates the policy of promoting settlement and reducing litigation costs. California courts have consistently imposed monetary sanctions under Section 271 and its predecessor statutes in response to similar bad faith litigation tactics and abuse of the judicial process. For instance, in remarriage of Battenberg, the Court of Appeals held sanctions against a party who pursued a, quote, bogus spousal abuse claim. A spouse's deliberate delaying tactics and bad faith conduct during divorce proceedings justified a $15,000 attorney's fee award as a sanction. Quote, reprehensible conduct falling short of bad faith, end quote, can warrant fee sanctions under the family law statutes. These authorities make clear that courts will award attorneys' fees as sanctions where, as here, a party has acted in bad faith or engaged in litigation abuses that thwart the policy of amicable resolution and fair dealing. In this case, respondent asserts that petitioner's conduct is more serious than the examples cited above. By alleging creating a false basis for a DVRO and requiring respondent to incur significant legal expenses, petitioner has increased costs and utilized court resources. This is the type of delay and expense that Section 271 is intended to prevent. Respondent respectfully requests that the court order petitioner to pay respondent's reasonable attorney's fees and costs resulting from this conduct as permitted under Family Code Section 271. The Court of Appeal has clarified that Section 271 sanctions must correspond to the actual attorney's fees and costs caused by the conduct. The requested sanction seeks only those actual fees and expenses incurred due to petitioner's alleged misuse of the DVRO process. Awarding these fees and costs will compensate respondent and help deter future misuse of the court system. If the court does not grant sanctions immediately, the respondent requests that the court defer deciding on the Section 271 sanctions until after the DVRO motion is resolved, thereby keeping the issue open for a later hearing. Waiting would let the court fully consider petitioner's responsibility for respondent's fees after the DVRO is addressed. This would protect respondent's right to relief under Section 271 and let the court focus on the DVRO first. Still, because of the clear litigation abuse and Section 271's focus on prompt action, respondent believes a sanctions award now is justified. Respondent asks the court to grant the requested fees and cost to ease the financial impact of petitioner's actions and to discourage similar tactics in the future. This would support the policy of encouraging cooperation and help restore fairness as intended by Family Code Section 271. Dated September 10th, 2025. Respectfully submitted, Omar Serrato. Declaration in support of motion to dismiss DVRO pursuant to CCP Section 473(b)(d), Notice of Intent to Seek Sanctions pursuant to Section 271. I, Omar R. Serrato, declare I am an attorney duly licensed to practice before all courts of the state of California and counsel of record for Respondent Michael Marraccini in this matter. I make this declaration based on my personal knowledge, my review of the court's file and docket, documents and records maintained in my firm's litigation file, publicly available court records, and evidence obtained in the course of my investigation. If called as a witness, I could and would competently testify to the facts stated herein. This declaration is submitted in support of respondent's concurrently filed motion to vacate the 2018 Domestic Violence Restraining Order pursuant to Code of Civil Procedure Section 473(d), the motion, and to provide notice of respondent's intent to seek sanctions under Family Code Section 271. The factual background, chronology, and legal grounds summarized below are the same as those set forth in the motion. From my review of the file and records in this case, petitioner applied for a DVRO on January 9, 2018. The court issued a temporary order on January 10, 2018 because the petitioner's claim necessitated immediate interim protection measures. Respondent filed a DV-120 response on January 22, 2018. After continuances for discovery, the parties entered a stipulated DVRO on or about July 10, 2018 for 2 years without any findings that the respondent committed domestic violence. This stipulation was significant because no evidence was presented, leaving the respondent's defense unexamined. Petitioner sought renewal on July 10, 2020. On September 11, 2020, the court extended the DVRO to July 10, 2025 because the renewal was uncontested, perpetuating the limitation on respondents' rights without fresh evidence of misconduct. On or about July 10, 2025, petitioner filed another request to renew. The renewal hearing is presently set for October 2025. Respondent opposed and now moves to vacate the underlying 2018 order based on extrinsic fraud and newly discovered evidence that was unavailable in 2018, which is significant as it challenges the order's legitimacy. New evidence unavailable in 2018, pattern of fabrication. Since entry of the stipulated order, substantial independent evidence has surfaced bearing directly on petitioner's credibility and her use of fabricated claims and evidence in related matters, including Arizona Paternity Action FC 2023-052114, After a trial in June 2024, the Maricopa County Superior Court found petitioner's testimony not credible, characterized her claim as fraudulent, identified a pattern of similar behavior, and ordered her to pay $149,000 plus in fees. Exhibit E is a true and correct copy of the findings after trial. Grand jury indictment. On or about May 25, 2025, a Maricopa County grand jury returned an indictment charging petitioner with fraudulent schemes, perjury, multiple counts, forgery, and tampering with physical evidence arising from the Arizona matter. A certified copy of the indictment, reflected in July 2025 filing, is attached as Exhibit F. Other corroborating materials include police reports, petitioner's own prior sworn statements, civil proceedings in Owens v. Gillespie, and documents evidencing forged medical letters and reused injury photographs, all described in the motion and authenticated below as Exhibits A through D, G through H. 5. Diligence and timing. Respondent acted promptly once this evidence crystallized. May 2025, indictment returned. July 10, 2025. Petitioner filed renewal request. August 25, 2025. Respondent filed opposition. September 10, 2025. Respondent filed the present Section 473D motion supported by this declaration. In my professional judgment, this sequence reflects diligence and falls well within reasonable time principles that govern equitable relief for extrinsic fraud. For instance, referring to cases such as Raplea v. Campbell, which emphasizes the necessity of acting within a reasonable time once new evidence is available, and further supported by the decision in St. Paul Fire and Marines Insurance Company v. Wiener, which indicates the timeliness of such actions, reinforces this sequence's appropriateness. The 2018 order was issued by stipulation without factual findings of abuse. First, a meritorious defense is established through the newly available evidence, judicial findings of fraud in a subsequent contested proceeding, and a felony indictment, which undermine the petitioner's credibility and reveal a pattern of fabricating evidence. Second, a satisfactory excuse is presented since this extrinsic fraud prevented a fair adversarial hearing in 2018. Third, diligence is demonstrated as the respondent promptly moved to vacate the order and seek sanctions once this evidence surfaced. This aligns with the equitable principles warranting vacater in equity. The motion details this showing and applies the Raplea three-part test: meritorious defense, satisfactory excuse, diligence. Authentication of exhibits, true and correct copies. In the ordinary course of my representation, I have obtained and maintained the following documents. Each is a true and correct copy of what it purports to be, and personal identifiers have been redacted where appropriate. Section 271 Notice Sanctions. Consistent with Family Code Section 271, respondent gives notice through the motion and this declaration of his intent to seek monetary sanctions in the amount of his reasonable attorney's fees and costs caused by petitioner's litigation conduct, including her misuse of the DVRO process and the resulting unnecessary expense to respondent. Fee records and ability to pay information can be submitted in camera or by supplemental declaration at the court's direction. Based on the foregoing and the evidentiary record summarized above, I respectfully submit that, because the 2018 DVRO was procured in an environment tainted by extrinsic fraud that denied respondent a fair adversarial process, and because the newly discovered independent evidence post-dating 2018, particularly the Arizona court's findings and 2025 indictment, undermines the integrity of the order, therefore, the equitable and statutory grounds set out in the motion justify vacating the 2018 DVRO and awarding Section 271 sanctions in an amount and manner the court deems just. I declare under penalty of perjury, under the laws of the state of California, that the foregoing is true and correct. Executed on September 10, 2025, at San Bernardino, California. Respectfully submitted, Omar Serrato.